So I have to thank Rebecca for doing the dirty work of the constitutional law lesson. I can skip over that part of my presentation. So anyway, what I'm going to be talking about today is it's a big process. The national process, regulatory process, it's a big, huge, massive bureaucracy, and localities, both state governments and also local and county, are very small, and yet they still can play a role in this process by educating themselves. So these are some of the things that I'm going to talk about in this presentation. So, okay, so what's the role of the local government? And it does play a role in the process, and that's something we're going to talk about. So what I'm going to get to first is just talk about these two different regulatory schemes that we have here in terms of pipeline siting and safety. And they're really two parts of an extensive process. There's the Federal Energy Regulatory Commission, which is involved mostly in the siting of interstate pipelines. So if something is going across state lines, FERC is going to have jurisdiction over it, and I'll talk about the scope of FERC's regulatory authority in a little bit. There's also the Pipeline Safety Act that pertains to safety issues, also over interstate or facilities impacting interstate commerce or impacting commerce. So the scope of jurisdiction between the two is a little bit different, but there is some crossover. So just also as background, I know this is a pipeline safety conference, and you may be wondering, well, why is the siting relevant at all? And they're actually very interrelated, because many safety issues can be remediated in advance if you can site a project in a prudent way. If you can site it in a way so that it doesn't create safety hazards to begin with, then you can eliminate some of the problems on the back end. And so that's why the regulatory component for siting is a very important part of safety, even if you're not necessarily addressing the safety issues in the siting process. So we'll talk a little bit about FERC first. Has anybody in here had experience with FERC regulatory process or the Federal Energy Regulatory Commission? Okay, I see some people I've worked with before. So anyway, FERC has jurisdiction on, over interstate pipelines under the Natural Gas Act, and it also has jurisdiction over liquefied natural gas facilities, and it has jurisdiction over LNG, both for import and export, although for certain types of export, the Department of Energy first has to give an authorization for export, and then FERC resumes the permitting process. So the pipeline certificates are issued under Section 7 of the Natural Gas Act. LNG is under Section 3. It's an important distinction for eminent domain purposes, because under Section 7, pipelines can exert the power of eminent domain under a certificate. You don't have that same authority for an LNG facility. Now, if there's a pipeline associated with the LNG facility, I mean, usually they'll be pursued as two separate permits. You can still have eminent domain for the pipeline part, but not for the LNG part of it. So where does FERC's jurisdiction, where is it limited? Well, FERC's jurisdiction, you know, in theory, almost everything affects interstate commerce. I mean, you know, there's case law that suggests that, you know, interstate commerce goes down to, you know, like a single transaction of grain sales. But so what happens with the Natural Gas Act is the Natural Gas Act actually limits FERC's authority over types of pipelines that do impact interstate commerce, but that the statute says FERC can't regulate. So those include gathering facilities and distribution facilities, and also a type of pipeline called a Hinshaw pipeline. And essentially that's a pipeline that may originate in one state, but it ends in another state, and the gas that is transported from out of state is used entirely within that state. So that's called a Hinshaw pipeline. There's only, I think, about 13 or 14 of them. It's not necessarily that relevant for these discussions. Now, even though FERC's authority under the Natural Gas Act, courts have said that FERC's authority over siting issues and everything relating to the siting process is preemptive, and the courts have actually said that FERC's authority preempts the field. So whether there's a conflict or not with state law, the court decisions going back like 70 years say that FERC's authority is completely exclusive. When you talk about something preempting the field, it doesn't matter, you know, whether somebody is conflicting with you or not. It's just kind of a get off my lawn thing. You know, like if a kid comes and is sitting on the edge of the neighbor's lawn and not doing anything, and the neighbor just, you know, wants to be nasty, it's like, get off my lawn. That's a good, I think, visual analogy for field preemption. You just, everybody out of the way. So FERC's authority there is very broad, but the statute also carves out certain areas where state and local authority is reserved. So those are the three statutes, I guess I call them the three musketeers: the Clean Air Act, Clean Water Act, and the Coastal Zone Management Act. And so those statutes still apply, and I'll talk about why those are important in a subsequent slide. So the role of PHMSA in the FERC process, essentially, and this is something that I've never quite understood, but PHMSA really comes in at the back end. When FERC issues a certificate for a pipeline, it will do, I would say, a very cursory analysis of safety. If somebody raises a safety issue, FERC will resolve it, but ultimately FERC's response to many safety issues that are raised is basically that once a pipeline is certificated, it has to operate in compliance with PHMSA standards. And so FERC's response is that, if they give the certificate and it's, the pipeline's going to comply with PHMSA, that will satisfy FERC's obligation. There are some cases, though, where the D.C. Circuit has reversed FERC, where FERC has gone a little bit too far in making assumptions about safety without having enough evidence to support it, and the courts have sent those cases back for another look. So the role of PHMSA, Rebecca mentioned that a little bit. This is the scope of their jurisdiction. They basically have jurisdiction over interstate facilities or other facilities that affect commerce. If it's something that's purely intrastate, then PHMSA isn't involved in that, and PHMSA also regulates the safety as part of the FERC regulatory process. As Rebecca said also, PHMSA has jurisdiction over the safety issues, not the siting standards. So anyway, the problem, again, we have is the preemption. I've already talked about these two issues. So now I'm going to talk about what local governments can do within these parameters, these preemptive parameters. So these are the strategies for success. And so the first one is you think kryptonite, not dynamite. So when you're a local government confronted with this all-consuming superpower, what do? Okay? What I say you do, or the strategy that I've taken with my local clients, is what I call kryptonite. There are those certain areas of vulnerability where national power is vulnerable to a particular statute, and those would be the Clean Air Act and the Clean Water Act. And these are some examples of cases where the exercise of state or local authority under those statutes has resulted in a realignment of a pipeline, or it's really mostly resulted in a realignment of a pipeline or the inability to construct a certain segment. So there's the Millennium Pipeline. It was originally proposed as like a 400-mile pipeline. It had to be reduced in size because of Coastal Zone Management Act issues. The state of New York wouldn't approve part of it. There's the Islander Pipeline. The state of Connecticut didn't agree with wouldn't issue a water quality certificate for it. And then there's the Myersville case, which is actually not entirely a successful issue, but I was going to talk about it a little bit because it introduced me to some potential areas under the Clean Air Act. So the Myersville case is it's a storage facility certification, but there's also a compressor station involved in it. Usually when you're dealing with a compressor station, you're going to have clean air issues because you're going to have emissions. And so the Clean Air Act very explicitly preserves a role for local authority. The Clean Air Act actually says within the statute that the Clean Air Act is not intended to disturb the authority of local governments over siting decisions. And so that reservation of authority is wrapped into the Clean Air Act. So in Myersville, the town of Myersville had denied zoning for this particular compressor station, and FERC approved the project, and it went on to move forward to get a Clean Air Act permit. And one of the things that we argued, or that we attempted to argue in the case, was that even though a certificate had issued under FERC, that the local government's ability to deny zoning was not preempted because they were exercising it under the Clean Air Act. So initially, that argument, the pipeline had filed a direct appeal in that case, which they have the ability to do, and we lost the issue there. But now it's being raised again. We're arguing it again in the appeal of the FERC certificate. So I think that those provisions in the Clean Air Act are very promising and I think that one thing that could have helped in that case more, although nobody really anticipated this, was to be very explicit in when you exercise your authority, make explicit that you're exercising it under the Clean Air Act if there is a case that involves emissions, because that way you're setting the argument up for a conflict between two federal laws rather than between a zoning decision versus a federal versus a FERC decision. So I think that those are some of the things that that local governments, landowners can look at. That's what I consider the kryptonite. Those are like the pressure points that can potentially result in a realignment of the project. So the next thing I say you should do in these procedures to expand the scope of your power is to focus on what's in your backyard. So know what your authority is, and that obviously is the purpose of this, is to really understand. Don't if somebody else says that there isn't that a local government doesn't have authority, don't necessarily listen. Make an independent judgment about it. And also, you're on stronger grounds as a locality or county if you're exercising your inherent powers. So I think, like in this Texas case, which my own view of this is that it may be a little bit of a quirky case. I don't know if other circuits will go that way, but one of the reasons I think the locality was on stronger grounds was because it had passed this law as part of in exercise of its zoning authority. So I think if you stick to the things that your municipality that you have authority over, a court is going to be more sensitive to that. One of the things that I think the town of Myersville had going in its favor is it didn't pass a zoning law in response or in reaction to a proposed interstate facility. Those are always, I understand that communities, there's political pressure to go out and take a stand, pass a law, say we're not going to allow these facilities here, but they're always going to lose. That's like the dynamite option. They're just always going to be losers. But if there's some way that you can plan or anticipate development in advance and start engaging in managed planning and land use decisions in advance of infrastructure coming through, you may be on stronger grounds to have it rerouted or realigned if it's eventually proposed. The last thing is, please participate for so many reasons. When the FERC process comes up, intervene in the process. FERC has inaccurate information on its page, its website. It says that you have to file 14 paper copies. Not true, not true. You zap one electronic pleading. Please do that. And I tell you it for this reason. Your citizens are coming to me. Your citizens are asking to hire me because they don't feel like their community or their county is getting involved on their behalf. And there are citizens who feel very strongly or who are impacted by these facilities who are bearing the cost. My costs are not even that high, but I get it. It's high for a group of landowners, and I make as many accommodations as I can. But it really shouldn't be something that citizens are doing. It's something that the community or the county should be doing. And the county or community is also going to have a lot more credibility in the FERC process than landowners. Landowners, unfortunately, for better or for worse, even now, and the landowners who are involved in these proceedings today are extremely sophisticated. The quality of the pleadings that I've seen from citizens in these cases, it's amazing. I mean, the only reason that I even have a chance in these cases is because of the work that the citizens have done. And so to then but even so, their views are not going to be taken seriously by FERC. But the views of organized government, a county, a mayor, they're going to be taken into account a little bit more. And FERC is going to be more willing to work with the towns or the communities. And so really in these proceedings, your residents shouldn't be leading the process. You should be leading the process. And once you're involved in the process, if you get involved early enough, you can raise concerns. So if you're a community where maybe your municipal infrastructure is going to be impacted, if you get in early and you raise the issue to the pipeline company, you raise the issue to FERC, there may be a way to make an accommodation. But you have to get involved early. Many times municipalities sit things out until the end, and then by the time they get in, it's already a fait accompli. So even though your rights within the process may be limited, it's still really, really important to participate. The last thing you could do is work with the other groups, the ones that are responsible for carrying out the Clean Water Act, the Clean Air Act, work with them and see if, there may be opportunities through working with those organizations to, to have a route changed or rerouted. Those are other things that can be done also. So, at the end, most of the people who I work with and most of the town governments that I've seen, nobody is really interested in stopping these projects. I think that everybody really wants to be able to come up with prudent siting decisions, with routing things in a way that makes sense for the public interest. And that, in fact, is FERC's mandate under the Natural Gas Act, is to site these pipelines in the public interest to meet the needs of people who need gas, but also to meet the needs of the communities and the ratepayers who are impacted by the projects. So I think that by counties and localities getting involved early, even if you think your rights are limited, I really think that that's the most important thing that you can do to preserve your autonomy and get an outcome that really, I think, is in everybody's interest. So I will now turn this over to the next speaker. Thank you.